mother. Let us see who is a mother. Mother may be a biological mother or adoptive mother. Biological means natural mother or adopted mother. Both are entitled to take a share from the son's property. When you come to the adoptive mother may be a widow, unmarried, or divorced. Why means a wife is not entitled to adopt a child under Hindu Adoption and Maintenance Act. It is only the father who has a right to adopt a child, but the consent of the wife is mandatory. That means a wife who is living with her husband has no right to adopt a child. So if the woman wants to adopt a child, she must be either a unmarried woman can adopt a child, widowed, she can adopt a child but in the name of her husband only, divorce can also adopt. So all these, whether the adopted mother is unmarried, widowed or divorced, she can take a share from the son's property. But stepmother is not entitled. Stepmother is not entitled to take a property from the stepsons, because there is no blood relation between stepmother and stepson. Marital status of the mother is irrelevant. Means whether the mother is married or unmarried, at the time of the birth of the child is totally irrelevant. That means an unwed mother is also entitled to take a share from the son's property. So an unwed mother is also entitled to take a share. Whether the son is a legitimate or illegitimate is also not necessary. That is not a disqualification to the mother to inherit the property. Whether the son is legitimate or illegitimate, mother is entitled to take a share from the son's property. Conduct of the mother is irrelevant. The mother may involve a live-in relationship either with the father of the child or with any other person. Mother is entitled to take a share from the son's property. A mother may remarry other than the father of the child. Even if she remarries any other person also, mother is entitled to take a share from the son's property. Even if the mother renounces the Hindu religion and converted to another religion, whatever the religion she converted, she is entitled to take a share from the son's property. So whether she converted, whether she is a live-in relation or whether she remarried, whatever may be the conduct of the mother is entitled to take a share from the son's property. Whether the son is illegitimate or legitimate, whether she is married or unmarried, these are not a disqualification. Only stepmother is not entitled to take a share. This is about the mother. What about the widow? Widow means wife of the intestate, widow. The widow take a share equal to that of the son. In separate property, there is no discrimination, all the heirs will get equally. So the widow will also get an equal share to that of the son. Here the wife refers to a spouse of valid marriage. What is required is, there must be a valid marriage between the intestate and the widow. If there is a valid marriage, then only she is entitled to claim a share from her husband's property. Suppose if the woman is a party to the void or voidable marriages, and it was annulled by a decree of nullity. The court declared it is a void. Then the Hindu male dies. She is not a wife, so she is not entitled to get any share from his property. And here also, the wife can, thus a second wife or a party to the bigamous marriage is not entitled to claim a share from the husband's property. But if the wife is a party to the voidable marriage, so you all know that voidable marriage is a valid up to what time? It is annulled by a court. Void marriage is a valid till it is annulled by the court. So the case is, for example, case is pending before the court, or just the woman decided that she want to go in court and the marriage is to get nullified. Before that, a Hindu male dies, but still she is a wife, because the court has annulled the marriage. She is a wife, she is entitled to get a share from husband's property. Suppose if the woman just living with a man not getting into the marriage, or she had a casual relation or occasional relation and then she is not considered as a wife and she is not entitled to take a share. But when come to the woman who involved in live-in relationship with X or Y, there are controversial views are there, but it was decided that a man and woman involved in a live-in relationship for a prolonged time, and the society also considered them as a wife and husband, then she is to be a wife and she is entitled to claim a share in the husband's property. So casual relation, occasional relations, they are all not considered, and she is not considered as a wife and she is not entitled to take any. Similarly, honesty or faithfulness or character also, there is a controversial views with respect to the character of the woman. There are different cases. That is, one is Daljit Kaur versus Amarjit Kaur, Punjab and High Court. They said that they are not, moral character and faithfulness are not relevant, so she can take a share, can claim property from the husband's. But Andhra Pradesh High Court, that was in Krishnamma versus Subramanya Reddy, they take the contrary view. They said that they are not relevant. So, in this way, there are controversial views regarding the honesty and faithfuls and live-in relationship, etc. But in live-in relationship, it was decided prolonged period. They lived together, and the society also considered them as a wife and husband, then they will be considered as a husband and wife. There is one more term where the wife applied to the court for the divorce. The first they have to stay in they are living separately under the decree of judicial separation. They are under the decree of judicial separation. And at that time, the Hindu male dies. Still she is in the separate, the court has not declared the divorce. Still they are in the judicial separation. The divorce has not been declared. Then the woman is to be considered as a wife and she is entitled to take a share. Because pendency of a litigation for praying a divorce is not the same as that of the divorce. The court must issue a divorce. The court must declare the marriage is a void. Once the divorce has been declared, then she is not a wife. Till then she is a wife and she is entitled to claim a share from the husband's property. And next is daughter. Daughter. As usual, natural daughter, adoptive daughter. But stepdaughter and illegitimate daughter are not entitled to take a share from her father's property. But a daughter born out of void or voidable marriage, they are considered as a legitimate child. Even though marriage is a void or voidable, if the children are born, the court considers them as a legitimate children. So once they are legitimate child, they are entitled to take a share from the father's property. So a daughter born out of void or voidable marriage is a legitimate child, so she is entitled to take a share from the father's property. Married, unmarried, both daughters are entitled to take a share from the father's property. The marital status, her chastity, her the financial position are irrelevant. Whether she is married or unmarried, she is entitled to take. Whatever the character she had, she is entitled to take a share from the father's property. Financial position also. For example, the daughter is a wealthy daughter. A wealthy daughter takes an equal portion of her share along with the poor son. Son is a very poor, he was living in the hut. She is like a Birla, Atta or Tata, but still both will get equal share. So financial position is also not relevant. Marital status is not relevant. Her character is not relevant. The daughter is entitled to take a share from the father's property. How she is married is irrelevant. Whom she married is irrelevant. Even if the daughter involved live-in relationship with some person is irrelevant. Even if she has an affair with the married man is irrelevant. Except stepdaughter and illegitimate daughter. A daughter of anyone, whether married or unmarried, whatever the financial position, whatever the character, whatever the affairs she had, whom she married, how she married, all are irrelevant, and she is entitled to take a share from father's property. Next, son. Son is also, as usual, natural son, adopted son. They are entitled to take a share from the father's property. And stepson, illegitimate son are not entitled. A son born out of void or voidable marriage is a legitimate child, he will take share. The term son does not include grandson. Son means son, it is not a grandson, but in some cases son includes grandson also. But here son does not include, the definition of the son does not include grandson. Son means son only, but includes the posthumous son. What is a posthumous son? A child in the womb. A child in the womb. So son includes whether the child is a womb of the mother or born. Whoever it may be, son includes both the son or a posthumous son, but not the grandson. Here the son has no right to claim the property by birth. Because in the ancestral property, the son has a right by birth in the grandfather's property, ancestral property. By birth he has a right. But such right is not available in the separate property or the self-acquired property. He cannot claim by birth. That's what I am saying, that even he can give it to the stranger or a charitable institution, the son has no right to ask, because he has no right by birth in it. He has no right by birth in, so same thing here also. A child born on the casual or occasional relationship, or there is a defect in the marriage, etc., they are not considered. But here also there is a contrary view has been taken in Babulal versus Nati boy. So here in this case, even if there is a defect in the marriage, even the casual relation, the child, they should not get suffered, so they will take the property. But the contrary view has taken by Mohan Singh versus Raniko. Different view has been taken by the Supreme Court decision. So contrary views are there with respect to this, and anyhow the Supreme Court decision is the final. We have to accept the Supreme Court what says.